Four things you must keep in mind. One is principle presumption of innocence, that accused is presumed to be innocent until proven guilty. Please keep that in mind when you strategize something for a case. Two, that burden of proof is always on the state. Burden of proof is always on the police. They have to prove their case. They have to establish the case beyond reasonable doubt, not the accused. It is their job. The only exception is there are some statutes which are framed by the government, some laws which are passed by the government, where they make it mandatory, where they create a provision and shift the burden of proof onto the accused. In IPC, there are only two offenses: abetment to suicide and dowry death, where if certain things are fulfilled, then the burden shifts, not otherwise. Otherwise, in every case, the burden of proof is on the state. Okay. Third principle is right to remain silent. Article 20, clause 3. No person accused of an offense shall be compelled to be a witness against himself. So right of silence is a very, very sacrosanct constitutional right available to an accused. Fourth is double jeopardy. Article 20, clause 2, that a person cannot be tried and convicted for the same offense twice. Right? These four things you have to keep in mind when you go to the court, when you fight any litigation on behalf of an accused. Right?